you're having any difficulty hearing me or understanding, would you please just let me know and I'll try to enunciate better. What I thought I would do in the context of registration and prospectus exemptions is to initially look at 4 conceptual matters that establish the framework for exemptions, and then in terms of the exemptions themselves to focus on those exemptions that are known colloquially as the private placement exemptions. I've selected those exemptions because they tend to be the more frequently used exemptions by ordinary commercial enterprises. And then after that review, discuss briefly some of the filing requirements that may in certain circumstances be triggered, and then to conclude with an overview of what is referred to in the paper really as the second layer of the closed system, or the resale restrictions that may come into play because securities have been initially taken pursuant to a prospectus exemption. I understand this morning that Stephen and Grant have reviewed the Act's treatment of transactions which are referred to as trades and distributions. I guess the key fact to bear in mind once you determine that a transaction involves a trade in securities is the requirement in Section 24 of the Securities Act that a person must be registered in order to effect a trade, or, as provided for in Section 34, be able to avail himself of an exemption. And on the other side of the coin, once you've determined that the trade you are talking about amounts to a distribution as defined in Clause 11 of subsection 1.1 of the Act, Section 52 requires a prospectus to be filed with the Commission and a receipt obtained from the Director. And then 71 qualifies that, saying that you need not comply with Section 52 or Section 61, which is a renewal prospectus if you have a distribution that goes longer than 12 months, for instance, a mutual fund. Section 71 of the Act qualifies that by providing a list of exempt distributions, in effect, trades that will not require compliance with Sections 52 and 61. In terms of the system itself, a key factor to bear in mind is whether the issuer of the securities is a reporting issuer under the Act. The definition of trade in the Act is an inclusive definition. It's not definitive. There are some transactions which the Act appears to implicitly deem to be trade, such as a dividend in specie. While there are arguments, I think there's at least one view that when a company dividends property to its shareholders, such as the shares of another company, I don't think it's clear on the face of the definition of trade that's in the Act now that that is a trade. There's a question of valuable consideration. But that type of transaction is deemed by the Act implicitly to be a trade, and it's a distribution as well. One of the key factors with reporting issuers definition is, though, that it is inclusive, it's definitive. If one cannot bring an issuer within its 5 branches, then the issuer is not a reporting issuer. Currently in the Act, the Commission does not have the ability or the power to declare issuer X to be a reporting issuer. In the amendments that have been circulated for comment, the draft amendments, they appeared in August the 10th edition of the Bulletin, there is a provision that would permit the Commission to deem certain issuers to be reporting issuers. But currently one must fit the issuer within the 5 branches of Clause 38 of subsection 1.1. So it's very important that in considering the use of exemptions, it's one thing to fit yourself within a pigeonhole, but you know, the extent to which you're going to be concerned may vary, whether you're acting for the issuer or for a prospective investor, because it's particularly important to the investor. The resale restrictions, one of the things they are all tied to is the reporting issuer status. And for instance, the hold periods commence in some cases with the date that the company became a reporting issuer. And so the reporting issuer status is vital to understanding the overall scheme of what is colloquially referred to as the closed system. In my paper, at page 33 of the materials, I've extracted a summary of the closed system that Gar Emerson prepared and has published. And in light of his work with the creation of the closed system in the mid and late 70s, I defer to his description, but basically what the closed system refers to on the prospectus side of a transaction, on the distribution side, is the fact that each and every trade in Ontario by an issuer in its own securities, and every sale of securities in Ontario by a control person will either require a prospectus, and Marlene's just reviewed some of the considerations that go into that route, will require a prospectus exemption. I'm going to speak about some of those today, and I've tried to survey most of the exemptions in the Act, or will require a ruling by the Commission under Section 73. That ruling, one makes application for such a ruling and basically seeks a ruling from the Commission that Section 52 or 61, in the context of a prospectus, would not apply to the transaction you're talking about. That's the first stage of what is known as the closed system, or referred to as the closed system. The second stage is that every holder of securities that have been acquired under the Act pursuant to a prospectus exemption may only be sold without a prospectus or without a Section 73 ruling from the Commission, on the condition that certain terms are satisfied. And the two primary terms are, firstly, that the issuer be a reporting issuer, and secondly, that the applicable hold period be satisfied as well. So in terms of addressing why do I need an exemption, you really have to take several steps in determining whether you have a trade, whether you have a distribution. And then in terms of the overall application of the exemption regime, I think it's prudent to also consider what is the status of the issuer in this transaction. Because, shortly after you do the exempt trade, someone is either going to, on the issuer side or on the investor side, and if it's on the investor side, hopefully it's been focused on before the shares or securities have been acquired, they're going to ask, when can I sell these? I assume, there's no problem with selling these, is there? And if they've been taken by way of exemption, you're going to have to work your way through the resale restrictions in order to assess whether there is a hold period, whether there isn't. And of course, on the issuer side of the coin, the reporting issuer status is beneficial in that it permits the issuer to issue securities pursuant to various prospectus exemptions. But on the other side of the ledger, it subjects the issuer to certain obligations under the Act. Briefly, there's the continuous disclosure obligations for financial statements. There's proxy material rules that have to be observed. There's timely disclosure rules of material changes, issuance of press release, preparation of a material change report, that type of thing. Insider reporting rules become applicable to insiders as defined under the Act. And the insider trading rules per se in Section 75 about using confidential information become applicable. So it's something that cuts both ways, but in terms of effecting private placements of securities, most investors will be interested in the securities you're talking about, but they'll also be looking down the road, how long do I have to hold on to these? What flexibility do I have in terms of selling them? And that type of thing. So you get both stages of the closed system then coming into play. As I mentioned at the outset, there's a couple of dozen possible exemptions that one can pigeonhole a transaction into. And in some cases, that's basically what you're asked to do, is to find a way for a generic type of transaction to be affected under the exemptions, because the issuer doesn't want to prepare a prospectus, and you know, if a ruling application isn't required, then we won't, you know, there's no point in making one if there is an available exemption. In terms of the exemptions that frequently come into play, there's 4 or 5 of them, and they're referred to by many people as the private placement exemptions. I'd like to just briefly focus on those. And in preparing the paper, I guess the thought that kept coming back to me was, this is at best an iceberg type of treatment of the exemptions. It's hopefully a little more than 1/8 of the iceberg that you can see above the water, but it's not close to being the whole iceberg. Each transaction has to be looked at in the context of the specific wording. We're talking about exemptions. My understanding is they ought to be construed narrowly in terms of their application. One must consider also the policy rationale that the Act is establishing in terms of providing a basis of information or a trade-off that an investor is sophisticated enough that he or she may not need the protection of the Act. So it's a very difficult exercise to definitively even deal with 1 or 2 exemptions, let alone the full range in the Act. And you know, if this can serve as a starting point, then I think it will have achieved at least one of its purposes. One of the key things to bear in mind in using the exemptions is that you cannot just look to one section in most cases. You cannot turn to clause, you know, X 1i 2b, and then it's all there. Currently with the Act, which came into effect in 78 or 79, there's the Act itself, and I'm only speaking about in terms of the exemptions. I mean, there's the Act itself, which in sections 34 and 71 and 72 is basically the exemptions. Then as a gloss on top of that, you have primarily sections 14 to 19 of the regulations. And then as a further gloss on top of that, you have policy statements that the Commission has issued from time to time that deal specifically with certain exemptions. So in considering any one of these exemptions, I think you have to go to at least those 3 areas to find out what you're talking about. And then if you have problems, you may get into previous decisions of the Commission, or it may merit a ruling request, that type of thing. So it's very important to appreciate that your sources in terms of the availability of exemptions they're sort of 3-pronged, and you just can't turn to, you know, Clause 71(1)D, which says if you have an aggregate acquisition cost for a purchaser who purchases as principal, you may have an exempt distribution. You've got to look elsewhere and make sure there are not some other rules. Turning to the first of what I refer to as the private placement exemptions, it's found in 71(1)A. It starts on page 37 of the paper. I don't propose to follow it through word by word, but essentially this is a transaction which involves a purchase by a bank, a loan corporation, a trust company, an insurance company, Her Majesty and Right of Canada, or a province or a municipal corporation, provided that their purchasing is principal. This is an exemption that's frequently used with banks taking positions in securities by way of an investment. And it's presumably the rationale for this type of exemption is derived from the resources and presumed sophistication of these entities. In the draft amendments that have been circulated, it's interesting to note that one proposed change in this particular section would be to include subsidiaries of any of those organizations, banks, loan companies, trust companies, insurance companies, provided that the bank or the other company owns 100% of the shares. So if there's a 100% owned subsidiary, then that subsidiary would have available to it the exempt purchaser status, so long as it's purchasing as principal. Presently in the Act, there's another category in Section 71(1)C, which is an exempt purchaser category, where an entity that doesn't fit within A, which feels it, other than an individual, I guess first of all, it's the important thing to bear in mind that 71(1)C of the current Act is not available for an individual. But for instance, a pension fund or some sort of retirement fund, I think that's the type of organization you see on the exempt purchaser list as often as any other. Doesn't technically fit within A, but with the resources they have, with the professional advice they have at their disposal, you can, by completing a Form 11 with the Commission, it's reviewed by the Commission and has to be, the application has to be accepted, you become an exempt purchaser for a 1-year period. So for instance, if you're acting for a foundation or for some unincorporated body that doesn't fit within A, or an incorporated body that doesn't fit within A but has, significant resources and or access to sophisticated investment advice and purchase securities frequently, you might want to consider filing a Form 11 and trying to obtain the exempt purchaser status. I guess one of the limitations is that in the proposed amendments, the prospectus exemption has been deleted, and it may be a temporary thing, but I guess these amendments started, December of '80. There was one very short set of proposed amendments that were circulated, and we're now into '84, and I don't think anyone has a very good handle on when we can expect this material to surface as legislation. But it is one current avenue that's available to organizations that can't bring themselves within any of the other exemptions, or most exemptions will rely on, most institutions would probably rely on the next exemption I'm going to talk about, 71(1)D, where the purchase price is $97,000 or more. So that, maybe it's not a particularly significant step, but if they participate, for instance, in venture capital situations where they might be putting up $75,000 time after time, there may be some scope for making that application and improving their situation. As I mentioned, the next private placement exemption I'd like to talk about is 71(1)D, which deals with a situation where the purchaser, once again, is purchasing as principal, and the trade is in a security which has an aggregate acquisition cost to such purchaser of not less than $97,000. Perhaps D is one of the better examples in terms of this three-pronged analysis of the availability of any exemption. If an issuer is planning to use 71(1)D in connection with a distribution of securities, and they propose to effect any advertising in connection with the offer of the sale, Section 21 of the regulations mandates that an offering memorandum, as defined in Section 21 of the regs, must be prepared, and included in the offering memorandum, the investor must be given a contractual right of action. I think Jeannie in her paper has, in the context of how one does a private placement, addressed the offering memorandum, addressed contractual right of action. But one must bear in mind to use 71(1)D in those circumstances and comply with it, one must be aware of the offering memorandum requirements that might be triggered. As well, the policy statements that the Commission has published in Section 6.1 deal fairly extensively with 71(1)D. Without discussing fully everything that's in policy statement 6.1 about 71(1)D, I just mentioned that, for instance, with respect to the aggregate acquisition cost of $97,000, the Commission points out there's two principal points to bear in mind. First of all, that must be a firm commitment for $97,000. The investor must be on the hook, if you will, for $97,000. As I understand, some years ago when I believe it was the movie tax shelters were the rage, some of these were structured so that so much money was put down. A promissory note was delivered for the balance of the purchase price. Let's say they priced it at $97,000 or $100,000. Promissory note was delivered for the balance of the purchase price, which tended to be the bulk of they tended to be highly levered in terms of how much cash today, how much tomorrow. And the note was also made either a non-recourse note in that the issuer said, I'm quite happy to limit myself to any proceeds that this venture earns, and I will take out the balance of the note first or only out of proceeds you receive from the movie, for instance. So there was no firm commitment by the investor in that case to ever put up $97,000. And in fact, if it was truly a non-recourse note, he would only put up the cash, which might have been $5,000. So firstly, the Commission in 6.1 is saying that the $97,000 has to be a firm commitment. Secondly, the $97,000 must be on a present value basis. If you're paying all in cash, it's a simple arithmetic calculation. How much money are you paying? If you're paying so much by cash and so much by note, you must present value the amount of the note using rates that they set forth. If it's a reasonable rate, you can use that. If not, I think it's prime plus 1. But you must present value that to the date of the investment, and that must be at least $97,000 or more. Secondly, the Act speaks of purchaser purchasing as principal. The Commission has indicated that it thinks it is inappropriate for unincorporated organizations to be formed for the sole purpose of permitting individual investors who are not putting up at least $97,000 to aggregate their funds and arrive at an amount of money in excess of $97,000 and then make use of the exemption. So for instance, if I had been buttonholed on the corner about, the next, how to double my money in 2 weeks and had spoken to the other 4 people up here and said, if you want to each put in $25,000, we can make this investment and we'll set up a trust and the trust will make the investment. We'll come up with, $125,000. It's over $97,000. We can just use the exemption. The Commission has said they do not feel that's appropriate. And in using this exemption, in addition to the filing requirement of the Form 20, which we'll discuss later, the vendor is required to file a certificate stating that, having employed reasonable diligence, he thinks each investor, each individual who's making the investment, so if there is an unincorporated organization, you have to go the next level down to the individuals, has put in at least $97,000. In terms of what the Commission regards as due diligence, I think they've indicated that a statutory declaration from individuals involved on the investing side would be satisfactory. There is a statement in the policy in this area where it says the foregoing is not applicable in the case of a corporation. I guess from a policy point of view, I have some trouble with that because the difference between sitting down and coming up with a declaration of trust for the 5 of us and sitting down and having someone come up with a numbered company, it's not all that much of a difference to me, but there is the statement. I'm not sure that in a bald case of 5 people putting in $20,000 each for the pure purpose of circumventing that amount of money limit, that the Commission wouldn't take remedial action, but there is the statement in the policy. And as I mentioned to you, the offering memorandum that may be triggered is a fairly difficult matter to handle, in that the definition of offering memorandum that's provided by the Act is sufficiently vague that it's very difficult to get a handle on what is involved in an offering memorandum. as Jeannie's indicated, the contractual right of action can sometimes be a problem for people in terms of, exactly what is it we have to give them. I think the intention is that the investor be given something that parallels the civil right of action under Section 126 of the Act in the event that there's a misrepresentation in the prospectus. I guess in part some of the difficulty that would surface in the context of a memorandum is highlighted if we turn to the consideration of the exemption in 71(1)P, which is frequently referred to as the seed capital exemption. It starts on page 51. Perhaps before I move to the seed capital exemption, I should just point out that under the proposed amendments to the Act, and I referred to this briefly before, the dollar limit for the use of what is now 71(1)D will be increased to $250,000. But as I understand the scheme, the use of an offering memorandum would be voluntary. So if an issuer wants to issue an offering memorandum in connection with the distribution, fine, and you must file 2 copies with the commission. But, for instance, advertising may not trigger it. It's difficult to state categorically because right now the offering memorandum requirements are in the regulations. The material that's been circulated so far only deals with sections of the Act, but it seems that in connection with the 71(1)D exemption, it would be a case where one was furnished voluntarily by the offeror, then you must, or the issuer, you must file a copy with the commission. And there's a definition of what an offering memorandum is in the definitional section of the Act. But in 71(1)P, the seed capital exemption, one can see some of the difficulty that an offering memorandum presents to an issuer and its advisors in looking at 2 little i's. One of the requirements for the use of the seed capital exemption is that each purchaser have access to substantially the same information concerning the issuer that a prospectus filed under the Act would provide. There's a variety of views on this as to exactly what is required. Some people take a fairly conservative view and say you're basically talking a prospectus, but it doesn't have to be filed with the commission. You don't have to get a receipt for it. Other people take the view that it's something short of a prospectus, but it contains the material facts for someone to make a reasonable, informed investment decision. In most cases, it's my understanding that an offering memorandum is frequently used to satisfy this requirement when you're using P. I mean, as the issuer's counsel or the issuer, you want to be satisfied that you have provided substantially the same information as the prospectus as would have provided. In many cases, an offering memorandum is prepared for that purpose. On the other hand, there are other ways of dealing with it. One of the most interesting I heard of was where an issuer made available to prospective investors a room which contained all of the company's records, everything, and you could send someone down and take a look. And it was all there, and they had a list of everything that was there, and they felt that's access to all the information concerning this company. And you can send someone down, and once they've had a look, you make your investment decision. In comparing this with 14, with the government incentive security exemption, which we'll look at next, absent my understanding of an offering memorandum frequently being used to satisfy this access point, there's no express obligation to use an offering memorandum. But there are various other things in 71(1)P which one should bear in mind in terms of using this exemption. It's designed to facilitate the raising of capital by junior companies. It's a one-time exemption. Once an issuer has used the exemption, you cannot use it again. It's for trades made by the issuer alone. There are limits on the number of prospective purchasers and purchasers. You can only approach 50 people, and you can only sell to 25 people. And under Section 20 of the regulations, the number of people includes people in Ontario and in any other jurisdiction. So you cannot, there are similar exemptions there's a similar exemption, for instance, in the Alberta Act, Alberta Securities Act, Quebec Securities Act, I believe, as well. So you couldn't parcel off 50 prospective purchasers here, whatever their limit is in Alberta. At least under our rules, it's an aggregate number of people you've approached. Three little I's deals with the question of advertisements and selling expenses, and they're basically limited to the services of professional advisors or registered dealers. In addition to providing the purchaser with access to substantially the same information that a prospectus would have provided, there's also a requirement that the issuer be satisfied in order to use the exemption, because technically it will be the issuer that is distributing the securities. That the issuer is dealing with an investor who, by virtue of either his net worth and investment experience, or by virtue of consultation with or advice from a person who is not a promoter of the issuer and who is a registered advisor or dealer, they're able to evaluate the prospective investment on the basis of the information they've been given. I have a lot of trouble working my way through this section. I mean, first of all, if you go on the first branch, you're looking at the net worth and investment experience of an investor. As to what level of net worth you're comfortable with, what level you're uncomfortable with, what level you know you're out of the ball game, I just don't know. By way of footnote, I referred to some of the SEC rules where they have I think they call them accredited investors, a category of the type of investor where if you're selling to that type of investor, it's an exempt transaction, and they've established some rules of thumb in terms of net worth, $250,000, or net income before taxes of so much over the last 3 years, that type of thing. I think I referred to one of the provinces, I think BC, has a policy statement it's for exempt purchasers, so it's not exactly this type of situation. And I understand Alberta and Quebec also have similar policy statements. But, you know, I think it's a judgment that has to be made as to whether someone's net worth is sufficient. Then when you couple that with investment experience, I mean, what if it's a wealthy individual who just doesn't invest all that much? Maybe that's why they're wealthy. But, I mean, you've got to put the two of them side by side, and both times you're making a judgment. I mean, is investment experience merely a question of frequency? I mean, maybe the guy invests a lot but loses. Maybe they invest very infrequently, but they're very successful. So maybe you say, well, you don't use that branch at all. You look at the second and you satisfy yourself that they have advice from someone who is not a promoter of the issuer, but is a registered advisor or registered dealer. It must be a registered advisor. That, I guess, is one interesting aspect to it in that some people who hold themselves out to be advisors, investment advisors, may not be registered advisors. Most of your investment dealer type of situation is going to be picked up by a registered dealer. But once again, I think it's worth asking the question or checking the Commission's list of registrants, because there seems to be new organizations all the time that have investments for people to put their money into. And, if you're using this exemption, as I say, there's a myriad of things you've got to satisfy yourself about. And, I particularly have a lot of trouble with that subclause A. The other type of investor is someone that's close enough to the issuer or close enough to that individual where the Act is prepared to say you can use the exemption. That's the senior officer or director, spouse, parent, brother, or child of such a person. In the amendments to the Act that have been proposed, there's a number of changes to the seed capital exemption. First of all, there's a deletion to the limit on the number of prospective purchasers. And it just speaks in terms of there's a limit on the number of people you can sell to. Just to make sure I get this right, since this is the area I have so much trouble with. The access to substantially the same information requirement has been deleted. So the lead-in to two little i's really just ends with each purchaser, and then you get into A and B. And in B, they've extended it to include affiliates, so it would be a senior officer or director of the issuer or an affiliate of the issuer. But I think there are still some very difficult questions in clause 2 little i's A to be satisfied in terms of as an issuer, and I think Jeannie has focused on some of these in terms of whether you obtain representations and warranties in your subscription agreement, whether you rely on a questionnaire. I guess with the first, you're really leaving it up to them to a certain extent to tell you, yes, I know we're using this exemption and I am someone da-da-da-da. I don't think it's a blanket answer. On the other one, I guess with the questionnaire, you're going to have to take that information and then make the judgment yourself. Another exemption that's frequently used by this type of issuer is what was referred to as the government incentive security issuer. And that's currently in the regulations in section 14G. As I mentioned to you, when you're considering any of the exemptions, I think you've got to bear in mind the sections in the Act, which are primarily sections 33 and 34 of the Act in terms of registration, and then sections 71 and 72 of the Act in terms of prospectus. But also you have to bear in mind roughly sections 14 to 19 of the regulations, and also section 140 of the regulations. It has some additional registration exemptions. But in 14G, it's somewhat similar to what we've looked at in 71(1)P. There are some differences. 14G would permit a trade by a promoter in the securities of an issuer of a government incentive security. Now, government incentive security is defined in section 15 sub 2 of the regulations and is elaborated on in the policy statements. In the policy statements themselves, there's a list of what securities have been designated to date by the Commission as government incentive securities. 15.2 basically says government incentive security is something that's designated by the Commission from time to time. In the policy statements in section 6, there's a listing of what are government incentive securities to date. Recently, the Commission designated certain scientific research tax credit investment vehicles as designated securities. I get one sort of practice point that I haven't had a chance to talk to the other members of the group, but personally, I haven't had a chance to look at the 13th edition of the debut version of the Act, but I know with the previous edition, I did not have much, I wasn't comfortable with their version of the policy statements. The Commission is frequently amending sections, adding material. They're very, very important. And I find it's a little bit more work initially to get the set developed, but to go back to the December 2482 bulletin where the policy statements were originally published, or to get someone set who's kept them up to date and work from there and put in your own stuff in terms of at least your office work is it's a lot more reassuring to me because, for instance, with the scientific research tax credit designation, if you weren't aware of that, and I don't know if it's picked up in here or not, but it's been within the last 6-7 months that they made the designation, and leaving aside what the federal government's done, that could be a fairly significant omission in terms of trying to design a transaction for someone that was going to issue these things, not to appreciate that if the instrument you were looking at fell within the designations, that they were exempt. And since the policy statements are very fluid, much more fluid than the Act or the regulations, it seems to me that something that's published once a year runs the risk of becoming out of date fairly quickly. And as I say, it certainly involves some trouble at the beginning when you're setting up your own set of policy statements in terms of putting them together and making sure you've got all the amendments and changes, but I think it's worth the effort over the long run. So once you have a government incentive security, and you may be able to fit within G, and as I said, in addition to a trade by the issuer itself, it can be a trade by a promoter. The numerical limits in 14G are higher than the limits in P. You can approach 75 people and sell to 50. Once again, Section 20 requires you to include all jurisdictions. It's not just in Ontario. Section 20 of the regulations is carried forward into the Act in the proposed amendments, where they set up the limits on the number of purchasers. They indicate quite clearly, in all jurisdictions, not just Ontario. Under 14G of the regulations, you are required to furnish an offering memorandum as described in Section 21. So there's an affirmative obligation to provide this offering memorandum. You will then, of course, be into providing a contractual right of action in the offering memorandum. Also in 14G, there's another requirement that you include the particulars of the professional qualifications and associations of every officer and director of the issuer and every promoter of the issuer for the preceding 5 years, insofar as that might be relevant to the undertaking that's proposed. So you've got the requirement to provide an offering memorandum, whatever that is, in general terms, and then you've got this additional requirement to provide the 5-year professional qualifications and associations of these individuals. Maybe in terms of what the offering memorandum necessitates in terms of content, it's interesting listening to Marlene describe the typical first draft of the description of business in the prospectus process, because when the issuer comes back with his description of everything they do, it can be a long way from the final version in terms of you put the two of them side by side, and if you white out the name of the company, you may not even know it's the same entity. A lot of that crops up with the offering memorandum. From the way it's described in the Act, it's a defined term in paragraph 21(1)(b), and without reading it all, I think the key portion is it's referred to as a document purporting to describe the business and affairs of an issuer that has been prepared primarily for delivery to and review by prospective investors so as to assist them in their investment decision. And they set out a number of things that it is not. For instance, an annual report is not an offering memorandum. So if you hand someone an annual report in connection with discussing a possible investment, that is not an offering memorandum. But trying to grapple with the words describe the business and affairs of an issuer, I think you can appreciate you can be all over the map. And I guess one of the difficulties with the offering memorandum experience the Commission's had over the last approximately 5 years is that the documents are delivered to the Commission. And I use the word delivery or delivered quite specifically because they're not filed and generally available to people. Some issuers put them on their public file, and if you can access the document through the public file. But if an issuer does not want to put it on its public file, then it's delivered to the Commission, and it's not available to the public in that sense. So it's difficult to go on anything other than your own personal experience. And I personally have had some dealings with maybe a dozen, but I am sure there are people at this table that have had experience with a dozen times some number, and then and the types of documents are, I think they're the ones I've seen, they vary greatly in terms of approach, length of description, comprehensiveness. The contractual rights of action in most of them are very different. I think they all have the same effect because of why they're in there, but, so I think it's been an interesting experiment for the commission, but I'm curious as to whether they think it's been as salutary as they had hoped when they put in these requirements for offering memoranda in certain cases. It's interesting in the proposed amendments that they will only require offering memoranda to be furnished in connection with this tax and the government incentive security, and also with a new exemption, which I'd like to refer to next, which perhaps call a development capital exemption. But those are the only two instances that are going to require it. There are other cases where you can furnish it voluntarily. But I think it'll be one interesting area to compare the new act or the amended act whenever it's promulgated, and the old act, to see whether we can discern whether the commission has been satisfied with the offering memorandum experience. As I mentioned, in addition to the seed capital exemption and the government incentive security exemption, the amendments contain an additional exemption which is referred to as the development capital exemption. I appreciate you probably don't have a copy of the amendments with you, but if you just wanted to jot down the section, it's section 78(1) V as in Victor. Pursuant to this exemption, an issuer will be able to raise in the aggregate $3 million. Now, that's a simple statement of what it does. You are only permitted to use the seed capital or the government incentive exemption once, and then you can move to this exemption. So it's a second level exemption, if you will. That's why development capital has been suggested as a short form for it. And in the aggregate, you will be able to raise $3 million. You will have to wait 12 months from your last use of either the seed capital or the government incentive security exemption or this exemption. You will have to furnish an offering memorandum. But it probably will add a great deal of flexibility to smaller issuers in terms of their ability to raise capital. Say those are 5 of the, what I would refer to as the private placement exemptions. In using any exemption, one ought to consider section 71 sub 3 in order to determine whether a Form 20 must be filed. In all the ones I've talked about, a Form 20 is required in most circumstances. There is an exclusion for banks or other lenders where they're taking the securities in connection with a loan. As well, offering memoranda must be filed, must be delivered to the commission in order to use some of the exemptions we've discussed before. That is the first level. Then on the second level of the resale of securities, one must look at section 71(4), 5, and 7 principally, and then track through which exemption you took the securities under and determine whether the conditions have been satisfied. The principal conditions are the reporting issuer status of the issuer and the length of the hold period. Section 71(4) deals with the private placement exemptions primarily and establishes a 6 or a 12 or an 18-month hold period, depending on the nature of the securities. If they are legal for life securities, if an insurance company could invest in them without use of the basket clause and they're listed securities, the hold period is only 6 months. If they're just listed securities, the hold period is 12 months. And if they're not listed and not legal for life, it's an 18-month hold period under 71(4). 71(5) deals with other exemptions, such as the amalgamation exemption, the takeover bid exemption. It establishes a 12-month hold period since the issuer became a reporting issuer. And then in section 71(7), there's a regime for control persons and for lenders who have taken shares by way of a pledge from control persons. It's a very complex section. You have to look at section 19C. Section 19C has to be read together with 71(7) because 19C imposes additional hold periods on on a seller in those cases. And as I say, once again, if I can leave you with one sort of general approach to exemptions, one cannot rely exclusively on the statutory provisions in the sense of only the Act. You must consider the regulations, and you must consider the policy statements at a minimum. And hopefully you'll be able to fit your transaction within those limits and not require either a prospectus or a ruling from the Commission. Thank you.
What I propose we do now is, I believe they have coffee outside. What I think might be a good idea if we just went out and got it, brought it back in. Is that appropriate? Sure. I think I saw the sign on the way in, but... And then in about half an hour we'll be done. I think Priscilla's comments from the Ontario Securities Commission are quite worthwhile hearing. And so if we can wind up in about half an hour, we'll just get the coffee and come back in, and we can go out and enjoy what's out there that day.